That's not what I want.
Good morning.
It's my drink.
I hereby call to order this 18th meeting of the Pennsylvania Public Utility Commission for the year 2018 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. As always, I ask that you please note the safety information on the inside of the cover of our agenda. The first matter on this morning's agenda is the approval of the minutes for November 8, 2018, and I will call upon Commissioner Sweet, who is the editor of the minutes.
Thank you, Madam Chair. I reviewed the minutes of the public meeting of November 8th, 2018, and move that they be approved as submitted. Thank you.
You have heard the motion to approve the minutes of November 8, 2018. Is there a second?
Second.
Second by Commissioner Kennard. Any further discussion or edits? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Moving on to our agenda, we'll call up our Secretary, Rosemary Chiavetta, to lead us through today's agenda.
Good morning, Madam Chairman. Good morning, Commissioners.
Good morning.
Your various offices and bureaus offer the following agenda items for your consideration. Therefore, let us begin on page 1. It is recommended by Director Monahan and the Bureau of Audits that the Commission release the audit report of the PECO Energy Company.
Is there a motion to adopt staff recommendation?
So moved. Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 2, it is recommended by Director Mumford and the Office of Competitive Market Oversight that the Commission adopt the recommended proposed tentative order regarding customer programs.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye. Aye.
Any opposed? The motion passes 5-0.
Turning to page 3, and matters presented by Director Sophie and the Office of Special Assistance. It is recommended that the Commission adopt in an omnibus motion the first 2 items on page 3 regarding Astral Energy and the PECO Energy Company.
Is there a motion to adopt staff recommendations?
So moved.
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
At the bottom of page 3, it is recommended that the Commission adopt the proposed opinion and order regarding the complaint of Kenneth McLean versus the Philadelphia Gas Works.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion?
Madam Chairman, I have a conflict statement stating that Crystal Sakavich on my staff was with OSA at the time, and she did not advise me in this matter and asked that it be entered into the record as if I had read it in its entirety.
Thank you very much. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 4, it is recommended that the Commission adopt in an omnibus motion all 3 items appearing on page 4.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 5, it is recommended that the Commission adopt the proposed opinion and order in the rate case of the Duquesne Light Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion? I do have a comment or a statement that I would like to place on the record and ask it to be entered into the record in its entirety, but I will give you an abbreviated version of it. Before the Commission for consideration of Duquesne's rate case, before the commission is the consideration of Duquesne's rate case. The proceeding proposes the adoption of 2 items, which I wish to highlight for support. The settlement includes a proposed electric vehicle charge-up pilot. Electric vehicles offer a more efficient and cleaner option to travel through increased mileage per unit of energy and reduced emissions. As well, the economic benefits of EVs continue to advance in line with developments in battery technology. These factors have supported interest in EVs and ultimately their sales. In fact, in October of this year, aggregate U.S. EV sales surpassed the 1 million unit milestone, with over 90% of these sales realized after 2010. This milestone exemplifies the enthusiasm and momentum around the EV marketplace. Nonetheless, there's still work to be done to facilitate the charging station access in an economic manner. The EV pilot supports the build-out of 2 types of EV chargers. First, it provides for investment in DC fast charging infrastructure for Duquesne itself and the Port Authority of Allegheny County. Second, the EV pilot supports investment in level 2 charging stations infrastructure for third-party entities. Duquesne will utilize information gathered from the EV pilot to inform itself and this commission in future rate designs. This proposal aligns with the Commission's recently approved policy statement facilitating regulatory clarity for third-party charging. The settlement also includes a provision permitting Duquesne to capitalize its development costs for cloud-based information systems. It is the duty of this commission to construct a regulatory climate which accommodates new technologies and capabilities in order to provide utilities with the tools necessary to satisfy and empower its customers. Permitting for the capitalization of cloud-based development costs aligns the interest of utilities with the new expectations of utility consumers. Further, the accounting treatment is consistent with the resolution passed by the National Association of Regulatory Utility Commissioners related to the regulatory treatment of cloud computing arrangements. I applaud Duquesne and the parties in this proceeding for putting these proposals before the commission, and I am pleased to support it. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing on page 5, it is recommended that the commission adopt the recommended opinion and order in the rate case of the PECO Energy Company's electric division.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? I have another statement for the record that I asked to be placed on the record in its entirety, but I will give you the abbreviated version. Before the commission, the partial settlement resolving issues related to PECO's proposed rate increase. Before the commission is the partial settlement resolving issues related to PECO's proposed rate increase. The partial settlement proposes for adoption of a pilot electric vehicle direct current fast charging rider. I commend PECO for bringing forth a proposal to stimulate the electric vehicle market in its service territory, and further commend the parties in the proceeding for their support and work in crafting PECO's pilot proposal. The 36-month pilot will require participants to provide PECO with data to inform the company and this commission on further rate design. This proposal aligns with the commission's recently approved policy statement facilitating regulatory clarity for third-party charging, and I am pleased to vote for approval on this proposal. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
At the bottom of page 5, it is recommended that the commission adopt the proposed opinion and order in the complaint of Peter Mimo versus the PECO Energy Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
So there's a motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? I just want to say on the record, I do have a verbal statement to say on the record. As we know, this case involves consumer Peter Mimo, who filed a complaint which alleged a reliability, safety, quality problem with its utility service due to numerous service outages in his circuit. He failed to appear at the scheduled hearing convened in July 13th of this year, the ALJ dismissed the complaint with prejudice for failure to prosecute. On August 21st, the complainant did file exceptions. So when a party fails to attend a scheduled hearing, such failure to appear will be deemed a waiver of the party's opportunity to participate in a hearing unless the failure was avoidable. While I agree, and let me emphasize that again, while I agree that with the timely disposal of this matter, what I do not agree with, and you guys have heard me say it before, I do not agree that this case should have been dismissed with prejudice. I have previously said that regarding my concern regarding the Commission's practice of dismissing the pro se complaints with prejudice as being inconsistent with Section 1.2 of our regulations and the Commission's own case precedent regarding the process. In cases where there's no reason to suspect that the Commission's administrative process is being abused, dismissing with prejudice protects the complainant's right to due process while respecting the Commission's administrative process. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0, noting my comments.
Turning to page 6, it is recommended that the commission adopt the proposed opinion and order in the complaint of Amy Granda versus the Pennsylvania Electric Company.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion? I do have a verbal statement. Once again, it is along the lines of what I previously stated in terms of pro se complainant. Once again, this person did not appear at the hearing that was convened in June of this year. As we know, when a party fails to attend a scheduled hearing, such failure appears to be deemed a waiver of the party's opportunity to participate in the hearing unless that hearing was unavoidable. Once again, I agree with the dismissal of the case, but I do believe that having it dismissed with prejudice is something that is inconsistent with not only our rules, but our case precedent. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended in an omnibus motion that the commission adopt the remaining 2 items appearing on page 6.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 7, and matters presented by Director Diskin and the Bureau of Technical Utility Services. It is recommended in an omnibus motion that the commission adopt all of the items on page 7, beginning with the tentative order regarding the electric generation suppliers, and continuing on page 8 to include all items on page 8, ending with the rate filing by Verizon North LLC.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Is there's a motion by Vice Chairman Place and I'll do a
A
joint.
second by Commissioner Sweet.
Second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 9, it is recommended by Chief Counsel Panque and the Law Bureau that the commission adopt the proposed order regarding the petition of the West Penn Power Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second? Motion, is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 10, and matters presented by Chief ALJ Rainey and the Office of Administrative Law Judge. It is recommended in an omnibus motion that the commission adopt the first 2 initial decisions by ALJ Jones and ALJ Vero.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
At the bottom of page 10, it is recommended that the commission adopt ALJ Cheskas's recommended decision approving the settlement in the application of Suez Water, Pennsylvania wastewater.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
I have a motion, Madam Chair.
Commissioner Sweet.
Thank you, and I would ask that my motion be placed upon the record as if I read it in its entirety. These applications come to us for consideration as a recommended decision, RD, of Administrative Law Judge Joel Cheskas, ALJ, approving a full settlement submitted by all parties of record without modification. While I have no issue with the settlement itself, there's an underlying issue which I believe needs to be identified and addressed. The Commonwealth Court issued a decision on August 18th, 4 months ago, in another water acquisition case, which also used the Section 1329 process, finding that the Commission's requirements for service of the application was inadequate in cases where the administrative action is adjudicatory in nature and involves substantial property rights. As the court stated, quote, because an increase in rates involves a substantial property right, ratepayers are entitled to notice of a commission's administrative proceeding in which a decision is made to increase rates in a subsequent rate-based proceeding, close quote. The court cites a prior decision as well as the U.S. Constitution as a support. The court concludes that whether individualized notice is required depends on whether the outcome of the proceeding binds the commission to increase rates, and that publication in the Pennsylvania Bulletin was not adequate notice to ratepayers. The court characterizes the increase in rates as a property right requiring individual notice. While the Commonwealth Court's decision is subject to a petition for allowance of appeal to the Pennsylvania Supreme Court, that court has not yet accepted the case, and there is no stay of the Commonwealth Court's case, the Commonwealth Court case I mentioned. Therefore, the decision of the Commonwealth Court in the Newgarden case is the law in Pennsylvania as we sit here. The holding specifically finds that the Commission's requirements for notice to ratepayers in Section 1329 cases is inadequate, and that this Commission is bound by that holding and must act accordingly. The court's holding, excuse me, and its interpretation of the statute raises significant impediments to the consummation of current transactions and the future of any new ones. It is my personal hope that there can be relief from this decision, either from the legislature or the Pennsylvania Supreme Court, that relief would both support the public policy set forth by the General Assembly in the Section 1329 statute, while protecting due process rights of consumers. This commission recognizes that the role of the public advocates has been to participate in commission cases and to protect those consumers that they are mandated by statute to represent. Because of the above, I regretfully conclude that the case should be returned to the Office of Administrative Law Judge to oversee the compliance with service requirements of commission regulations and to handle as appropriate any protests which may be filed against these applications. I recognize that this process has the potential to take the case beyond the 6-month litigation period provided in the statute, and I regret that. However, this issue is too important to ignore, and the 6-month litigation period is directory, not mandatory, meaning no ill consequences will result from missing it just this once. The statute, the deadline statute, cannot be construed to trump an appellate court decision that's based on constitutional principles. The notice issue should not occur again in the future, as the parties and the commissioner are on notice of the Commonwealth Court's requirements and will take action to comply at the beginning of new cases. Therefore, I move that the recommended decision of Administrative Law Judge Cheskas is held in abeyance consistent with this motion, that the applications are remanded to the Office of Administrative Law Judge to oversee the compliance with the notification, or the notice provisions, excuse me, of the Commission's regulations, consistent with the Commonwealth Court order in McCloskey v. Pennsylvania Public Utility Commission, number 1624, CD 2017, and I'll withhold further citation. And that the Office of Special Assistants prepare an appropriate order consistent with this motion. I realize, just as an ancillary comment, Madam Chair, that that there are some on the commission who believe that we're somehow bound by a decision that we made back in October under not exactly the same facts, but a somewhat similar fact pattern. First of all, I think the fact pattern was different enough in that case. The decision was only recently rendered and hadn't quite been digested by everyone. Now we're 4 months later, and I don't think we have that particular excuse. I remember, I'm not sure, Winston Churchill said everything, so he may have also said that if you find yourself digging yourself into a hole, the first thing to do is stop shoveling. We should not, I think we perhaps made an error in the prior case, and at a minimum, we should stop shoveling and not make that same error in this case. Thank you, Madam Chair.
You have heard the motion of Commissioner Sweet. Is there a second?
Second?
A second by Vice Chairman Place. Any discussion? I do have a statement that I wish to be spread upon the record in its entirety, and I will just give you an abbreviated version. I wish to highlight the uniquely challenging situation that this proceeding and the recently approved 1329 application proceeding of the Pennsylvania American Water's acquisition of the Salisbury Township wastewater system has presented to this commission. During the pendency of both the Mahoning and Salisbury proceedings, the Commonwealth Court issued a decision declaring the commission's requirement for Section 1329 applications were inadequate, and you heard some of that in Commissioner Sweet's motion. The Commonwealth Court decision, or the New Garden decision, which is also a point of consideration in our discussion, now requires applicants utilizing 1329 to provide individual notice to all customers of the purchasing utility and all customers of the municipal utility being purchased. This new requirement augments the Commission's original notice requirements in these proceedings. And I note that both applications in the Salisbury proceeding and the instant proceeding met the notice of requirements at the time of the filing. These original requirements mandated the following: that there be publication in newspapers of general circulation, that service of applications on municipal entities whom are part of the selling entity's original territory, and the service of applications in neighboring municipal water authorities, and service of application on the Department of Environmental Protection. Understanding this background, I focus my attention to the existing requirement of Section 1329 of the statute, which mandates that the Commission shall issue a final order of application submitted within 6 months of the filing date. So this leads to the dilemma only applicable to the Salisbury proceeding and the Mahoning proceeding: the conflicting requirements of the Commission to meet the mandated statutory 6-month timeline while also meeting the newly court-mandated notice requirements. Since the Salisbury proceeding and the Mahoning proceeding are both full settlements, that makes it even more difficult. Since no entity that is a party of the New Garden discussion and an active party to the instant proceeding on the Salisbury proceeding has filed for action to update notice requirements on these unique cases, and since both of these proceedings did satisfy the legal notice requirements at the time of the initial filing, I find adoption of the respective recommended decisions to be reasonable. And with that, I echo that this transitory issue is uniquely germane to the Salisbury proceeding and the Mahoning proceeding, and all future 1329 proceedings must be compliant with the New Garden decision. So with that in consideration, I will be voting no on Commissioner Sweet's motion. Any further discussion on the motion?
Chairman, I do have a verbal statement as well. I appreciate Commissioner Sweet's motion this morning. I've got to respectfully disagree with the notion that it is a different fact pattern. I agree with your statement that I believe it is on point and does serve as a precedent for this case this morning, and therefore I will be voting no as well.
Any further discussion? Hearing none. On the motion, all those in favor say aye.
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 Any opposed?
No.
I will also be voting in the negative, so the motion fails 2-3, noting the dissents of Commissioner Coleman, Commissioner Kennard, and myself. That brings us back to the original motion, the staff recommendation, which is before us. Any further discussion on the staff recommendation that's before us?
Madam Chairman, I'd like to be associated with your statement, and with all due respect to Winston Churchill, I'm going to stop digging at the end of this case.
Too late. You're already deep in the mud.
I'm not digging anywhere. Just want to let everyone know that. Any further discussion? Hearing none. On the staff recommendation, all those in favor say aye.
Aye.
Any opposed?
Opposed.
The motion,
For the reasons stated in my motion.
correct. The motion passes, I heard 4-1, noting the dissent of Commissioner Sweet.
Turning to page 11, there is your motion, Madam Chairman, regarding the proposed pilot for telecommunications relay service.
I ask the Vice Chairman please preside while I offer my motion.
Thank you, Chairman. I would like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
Thank you very much. On July 8, 2015, the Commission approved the Department of Labor and Industry's Office of Vocational Rehabilitation's petition to fund a pilot project involving the distribution of wireless equipment to income-eligible persons with disabilities in Pennsylvania. That wireless expansion initiative pilot has concluded, and I propose that we now take the next step to establish a permanent and ongoing wireless expansion initiative program. The Office of Vocational Rehabilitation, or OVR, proposed a 3-year budget in which the distributed equipment is to be replaced every 3 years. OVR proposes a budget of $199,393 for the first year, and the program consisting of $70,750 for the initial startup cost and another $129,143, of which $62,390 is for the equipment and $66,753 is for the non-equipment cost. Budget years 2 and 3 would remain at the $129,143 level, with identical allocations of $62,390 for equipment and $66,753 for non-equipment costs. I support using the initial budget at this time for 2 reasons. The first is there is a need to focus on implementation and outreach at the outset. Therefore, OVR should be looking to lower the expense related to administration of the program and increase the proportion of expense associated with the distribution of equipment, effectively lowering the non-equipment cost as a percentage of the overall budget. Second, this is the only budget proposed in support of the petition. On that point, I believe it appropriate to require OVR to commit to further evaluating the budget and timing its next budget proposal to the Commission to coincide with the Commission's evaluation of a TRS budget and annual surcharge recalculation. The budget that I propose today is an initially small but important step towards enhancing communication capabilities to low-income Pennsylvanians with disabilities. However, given the potential universe of persons in Pennsylvania that may be eligible to participate in this program, I will require OVR to review its budget and assess its program annually to evaluate how well it is effectuating its purpose. I also require that the program operate on a more geographically balanced basis using the assistive technology resource centers or a functional equivalent. A permanent wireless equipment distribution program better ensures compliance with Pennsylvania law, requiring the Commission to support a TRS program to facilitate communications for persons with disability by wire or radio. This permanent and ongoing program is warranted because communications for impaired citizens by wire or radio must be reasonably comparable to communications by wire or radio available to non-impaired citizens. So let me say upfront that under this program, the Commission is supporting a wireless device distribution program in which the qualified consumer must still buy the underlying wireless access service. Like the current telecommunications device distribution program, we are approving a budget that provides equipment to qualified individuals at or below 200% of the federal poverty level to better provide equal access to communication technology to the hearing impaired community. Therefore, I move that, in the spirit of Christmas, I will not read 14 paragraphs of my moving statement, but I move that. Get down to the last one. The Office of Special Assistance, in taking in consideration all 14 moving paragraphs, in consultation with the Bureaus of Technology, Technical Utility Services, and Law, prepare an opinion and order consistent with this motion, and that the entered order be served upon the Secretary of the Department of Labor and Industry, the Office of Vocational Rehabilitation, the Office of Consumer Advocate, the Office of Small Business Advocate, and the Commission's Telecommunications Relay Service Advisory Board, and a copy of an entered opinion and order arising from today's action be published in the Pennsylvania Bulletin and posted on the Commission's website.
Having heard the motion, is there a second?
Second.
Seconded by Commissioner Kennard. Any discussion?
Vice Chairman Place, I do have a verbal statement on the matter.
Commissioner Coleman.
First, I'd like to commend the chairman for her holiday spirit and not reading all of the ordering paragraphs. I also want to commend the staff that, as you've heard in the chairman's motion, that this is a significant sea change moving from a wireline service to a wireless service. So I'm going to be supporting the chairman's C motion to establish a permanent wireless equipment distribution program. And I do so really for three reasons. The first is the chairman indicated in the numbers here that I believe this is a very measured wireless equipment distribution program. Secondly, it follows the expert recommendations, again, moving us from an older technology and embracing a new technology. And thirdly, I believe that it properly balances the interest of all of the parties involved. So thank you.
Any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Motion carries 5-0. The gavel is yours.
Thank you very much.
Madam Chairman, that concludes the regular agenda. We now turn to the carry-in agenda. And on page 1 of the carry-in, it is recommended by the Office of Special Assistance that the Commission adopt the proposed opinion and order granting OCA's petition regarding Columbia Gas of Pennsylvania, pending review of and consideration on the merits.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing on page 1 of the carry-in, it is recommended by the Law Bureau that the Commission adopt the proposed order regarding the Pittsburgh Water and Sewer Authority.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning to page 2 of the carry-in, there is the motion of Commissioner Sweet regarding Customer Assistance Program shopping.
Commissioner Sweet for your motion.
Thank you, Madam Secretary. I ask that my motion be entered into the record as if I read it in its entirety. The Public Utility Code requires that electric distribution companies, EDCs, offer universal service programs. The portfolio of universal services includes, among other things, customer assistance programs, CAPS, which provide lower monthly payments and arrearage forgiveness for certain eligible low-income customers. The code also provides for electric competition. EDCs provide default service for those customers who have chosen not to switch to an electric generation supplier, or EGS. EDCs are required to submit default service plans regarding their provision of default service. Over the years, many of these plans have expanded to include a variety of issues, including how and when and under what circumstances CAP customers may shop. In PPL and First Energy's most recent default service plan proceedings, it was shown that a majority of CAP customers who switched to EGS paid rates, or who switched to EGSs, paid rates higher than the utilities price to compare. We found that this practice causes harm because generation rates charged to CAP customers affect the asked-to-pay amounts for these customers. Higher rates make it more likely that CAP customers will exceed their monthly maximum CAP credits and incur charges that they may not be able to pay. If CAP customers are unable to pay their bills, uncollectibles are increased, which are then recovered from the rest of the utility's residential ratepayers. As a result, we directed both PP&L and First Energy to make changes to their CAP shopping programs to help limit that harm that accrues to both CAP and non-CAP customers. Collectively, PP&L and the 4 First Energy utilities serve approximately 3 million of this Commonwealth's over 5 million residential electric customers. Of those, PP&L and First Energy have almost 430,000 of Pennsylvania's roughly 630,000 confirmed low-income customers. Additionally, these 5 utilities serve nearly 765,000 of Pennsylvania's approximate 1.3 million estimated low-income customers. This is a significant portion of Pennsylvania's electric customer base that is, or could in the future be, participating in CAP programs. This commission has already taken steps to prevent both CAP and non-CAP customers in those 5 service utility territories from harm resulting from inappropriate CAP shopping programs. Although EDC caps differ, in all caps, customers are at risk of using their CAP benefits more quickly if they are paying rates higher than necessary as compared to the PTC. Additionally, all EDCs ultimately recover uncollectibles from ratepayers, and as such increase CAP default rates due to shopping at rates higher than the utility's PTC harms non-CAP customers as well. Therefore, I propose some areas of uniformity in CAP shopping practices that EDCs should include in their next default service plans. Specifically, in addressing CAP shopping in their next default service plan filings, EDCs should include, number 1, a requirement that the CAP shopping product have a rate that is at or below that EDC's price to compare at all time periods of the contract, the contract that exists between the EGS and the customer. Secondly, a provision that the contract between the EGS and the CAP customer contains no early termination or cancellation fees. And thirdly, that provision that at the end of the contract, the CAP customer may re-enroll with EGS at a product that meets the same requirements as outlined in my numbers 1 and 2 above. They may switch to another EGS offering a product that meets those requirements or be returned to the default service program. The mechanics of the CAP shopping programs will still be determined through the default service plan proceedings. It is appropriate for these issues to be addressed in each utility's next default service plan proceeding so as not to impact the current commission-approved programs and to allow for due process for all parties. I recognize that PECO's current default service plan proceeding is stayed in the Office of Administrative Law Judge. I encourage the parties in that proceeding to consider the provisions outlined in this motion when activity in that litigation resumes. Inclusion of these CAP shopping requirements balances both the intent of the Competition Act to allow for shopping while, quote, ensuring that universal service plans are adequately funded and are cost-effective, period, close quote. The Commonwealth Court's decision in Cause PA held that the Competition Act does not demand absolute and unbridled competition. As reiterated by the Commonwealth Court in RISA, the Commission may, quote, may bend competition so as to give way to other important concerns, such as ensuring that universal service plans are adequately funded and are cost-effective. The provisions proposed herein provide a methodology to ensure that both cap and non-cap customers avoid harm while still allowing for competition to occur. Consistent with the Commonwealth Court's statement in RISA, any cap customer is free to shop outside the specified program, but a cap customer shopping for a product which does not fit these requirements would be removed from cap. Additionally, if any party believes it can show through a default service plan proceeding that there is a reasonable alternative to the scenario included herein, where harm will not be incurred by either cap or non-cap customers, they're free to propose such a model. In order to promote uniformity in the development of these programs within EDC default service plan proceedings, I propose that a policy statement outlining these recommendations be issued for comment. Therefore, I move that, number one, the Law Bureau prepare for this Commission's consideration of a public meeting no later than February 28, 2019, in order to amend an existing or create a new policy statement that is consistent with this motion. Secondly, the Commission order and proposed policy statement be served on those parties outlined in my full written motion. Third, the Commission order and proposed policy statement be published in the Pennsylvania Bulletin and subject to the commenting timeframe outlined in my full written motion. And finally, following the comment time period, the Law Bureau prepare a final order and policy statement. Thank you, Madam Chair.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Commissioner Kennard. Discussion on the motion.
A statement on the matter?
Vice Chairman Place.
Thank you. Of course, support efforts to ensure that cap shopping is not harmful and costly to either cap participants or other ratepayers, and support more uniform cap shopping requirements. Thus, as this motion suggests, I am interested in stakeholders providing comments if there are any other potential solutions with supporting data that the Commission should consider. I welcome comments to the proposed policy statement as to whether or not EGS fixed price offers to cap customers should alternatively be required to be at or below the price to compare at the time of the offer, subject to provision 3 in the motion, upon expiration of the fixed price period, and whether or not such fixed price contracts should have a maximum fixed price term period. With that in mind, I request that interested parties provide additional information to help guide our decision-making. I'm interested in information that will help us identify the underlying causes of higher historical EGS prices to cap customers. If parties have information and analysis to further as to whether initial fixed price contracts at or below PTC at the time of the offer were the cause of the cap customer premiums, or whether, for example, such premiums resulted from the repricing terms of the EGS contract with cap customers, the Commission will have an opportunity to review this information and assist in our review of the comments prior to the drafting of the final policy statement. My concern here in layman's terms is that I want to ensure that cap customers have the potential to benefit from potential involvement or participation in the competitive markets. There is an upside. There's a downside, but there's also an upside. And if our prescriptions are so prescriptive and limited, they will not be products in the market. And if we see the situation where there simply are no products, therefore the cap customers cannot benefit from potential uplift. And that is also equally harmful. So with that in mind, that's why this is a conundrum. That's why this is difficult not to crack. And I look forward to comments on these issues. Thank you.
Thank you, Vice Chairman Place. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Continuing on page 2 of the carry-in, there is the motion of Commissioner Kennard regarding the telecommunications relay service proposed pilot.
Commissioner Kennard, you are recognized for your motion.
Thank you, Madam Chairman. I ask that my written motion be read into the record as if I had read it in its entirety. My motion is a companion to the motion of the chairman's that we just passed in regards relay service in Pennsylvania. The Pennsylvania Telecommunications Relay System was established in 1990, 27 years ago, through the joint efforts of this commission and the Pennsylvania Telephone Association, representing the incumbent telephone companies. The year 1990 is significant because the Americans with Disabilities Act was also signed into law by George Herbert Walker Bush at that time. At that time, the telephone company's copper landline was the sole source of communications. There was no wireless product. There was no cable telephony. There was no internet. There was no Wi-Fi. The local voice and data markets were monopoly dominated and regulated by us as such by the incumbent telephone companies. The solution at that time was therefore simple. Hearing and sight impaired communities used especially designed equipment that attached to the landline network and to live operators that provided interpretive and other services such as media reading. Funding was similarly ILEC focused. TRS and related equipment programs were funded by a monthly surcharge imposed upon incumbent landline telephone company customers. So in effect, we had a closed loop, a service of landline funded by other landline customers. Today, technology that did not exist in 1990 is now the dominant form of telecommunications in our society. The small computers that we all carry around in our pockets and purses opens a whole new solution to the hearing and speech impaired community. We use them to rely upon the powerful attributes of these machines without a second thought. And the electronic mail, text messaging, voice to text, video calling, and numerous other technologies incumbent in these machines have radically changed the landscape for TRS. So today we agreed under the chairman's motion to change the device portion of that effort dramatically. We are going to now fund the TDDP program by a distribution of wireless devices to eligible persons with disabilities. And I want to thank Chairman Brown for her leadership on this issue because it is nigh time that we did this, and I appreciate Temple undertaking a pilot program upon which we can gauge the success and the need for this system. And the success stories told in Temple's May report are moving and inspirational. The wireless devices can do so much more for the hearing and speech impaired community than traditional devices can. But today, as we reshape the devices, we need to review the program. The smart machines, the smartphones, are part of a total trend nationally. Customers are migrating away from wireline service. They're all cutting the cord. If we don't have 50% of homes in this country without traditional wireline phones, we are close. We are very close to it and closing in on that mark. Consequently, the number of access lines supporting the TRS program have declined dramatically, falling 23% in just the last 5 years. And this is the throes of a trend that started in the year 2000. In other words, as we expand the TDY program, the funding base is shrinking. We cannot continue to ask the remaining customers of declining legacy product to fund and promote the expansion of a competitor's network. If we're going to fund a wireless business model, we should explore wireless service provider participation. So by this motion, I'm asking the Commission's Bureau of Audits to examine the historical spending and funding trends and analyze the sustainability of the current program design. A detailed and specific request is detailed in the written motion. I'm also proposing to form a task force of TRS advisors, participants, administrators, service providers, and advocates to take a fresh look at our TRS program and come up with ideas on how best to incorporate the massive changes in technology and society since 1990. The TRS advisory board members have expressed their enthusiasm in convening and leading a task force of stakeholders to review the TRS programs. I'm confident that with Chairman Kay Tyberg's leadership and the advisory board can lead us to the options that we may use to reform this program. The written motion identifies the participants and the scope of their charge. The task force is requested to reimagine the entire process. Fundamental issues such as the continued need for the TRS relay service and the conventional use of devices should be examined. Maybe we should take a move to wireless completely. Maybe the 1990 solution has outlived its usefulness in its entirety. Just as the telecommunications industry, even on the wireline side, evolves from copper wire to fiber wire, we need to look at those kind of issues comparably for the TDS program. If equipment is configured to handle SIM cards, which I believe they are, then we need to look at how the CMRS services should be similarly configured. So in view of the chairman's acknowledgement of the Christmas holiday, I will not read my 12 ordering paragraphs either. And, but I do move that the Office of Special Assistance, in consultation with the Bureau of Technical Utility Services and the Law Bureau, prepare an opinion order consistent with my written motion. Thank you.
Thank you, Commissioner Kennard. Is there a second to his motion?
Second?
Second by Commissioner Coleman. Any discussion on the motion?
I have a statement on the matter.
Vice Chairman Place.
Madam Secretary, I ask that my statement be entered in the record as I've read it in its entirety. I respectfully disagree that the initiative that is proposed today to engage the Commission's Bureau of Audits and to institute a separate task force for the comprehensive reexamination of the existing TRS framework and the associated TDP is a useful application of Commission resources. Our Bureau of Audits routinely and periodically conducts extensive audits of both the TRS programs and the TDDP. Consequently, I'm reluctant to expand the scope of those auditing activities without the precise and clear goal. Similarly, I do not agree with the institution of a dedicated task force for the comprehensive reexamination of the TRS and TDDP programs. Such generic investigative inquiries are preferably and usually framed through the advanced and formal dialogue with all the interested and potentially active and participating stakeholders. This approach is also conducive to the better management of such generic inquiries and the production of useful policy recommendations for the Commission's future use. Furthermore, I question the purpose of this comprehensive reexamination of the TRS and TDDP programs at this time, as these programs exist and continue to function under applicable statutory directives of both Pennsylvania and federal law. Thank you.
Thank you, Vice Chairman Place. Any further discussion on the motion?
Chairman, I do have a verbal statement as
Commissioner
well.
Coleman.
Just wanted to go back to my previous comment that we're making a significant sea change here in the use of technology, moving, as Commissioner Kennard has eloquently indicated in his motion, from a wire line service to a wireless service. And as Commissioner Kennard has indicated, this is a fast-moving technology, and the Commission is trying to get up to speed in modernizing this program, as we've indicated in Chairman Brown's motion earlier this morning that we've approved. What Commissioner Kennard, in my view, is suggesting is a level of transparency. And I think that in any business model, this makes perfect sense and is certainly appropriate. I agree with the Vice Chairman, as he's noted, that this is a comprehensive reexamination. And I think that is certainly appropriate when we're making this kind of a change in the technology and making sure that what we're doing is current with the technology, the service, the devices, the selection of devices, the distribution of devices, and certainly the funding for the program. So for those reasons, I am going to fully support Commissioner Kennard's motion this morning. Thank you.
Any further discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed?
The motion passes 4-1, noting the dissent of Vice Chairman Place.
Madam Chairman, that concludes the carry-in agenda. We now turn to the supplemental carry-in agenda. It is recommended by the Office of Special Assistance that the Commission adopt the proposed opinion and order regarding the complaint and petition of Megan Flynn et al. Versus Sunoco Pipeline LP.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
I have a statement on the matter.
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be placed into the record as if I read it in its entirety. The matter before us is procedural in nature, that there is a defined regulatory review period when certified questions are addressed to the Commission, in this case 30 days. This case is not unique in that this Commission must perform due diligence to comprehensively review all of the pleadings to address the matter. There was insufficient time to adequately adjudicate this case by today's public meeting, given the docket's procedural schedule, subsequent filings, and significant factual issues. That said, I encourage expeditious review and would support disposition, if warranted, by the addition of a public meeting before the next regularly scheduled January 17th public meeting. Thank you.
Thank you, Vice Chairman Place. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed?
The motion passes 4-1, noting the dissent of Vice Chairman Place.
Madam Chairman and Commissioners, that concludes all agenda items to be considered in 2018. All of your bureaus and offices bid happy holidays to all, and to all a good night.
First of all, thank you very much, Madam Secretary, first of all, for your work and being able to step into that role earlier this year as we had a change. And we just want to thank you for it, and you've done an excellent job.
Thank you very much,
And
Madam Chairman,
also
Commissioners.
commending you, we would also like to take this opportunity to just acknowledge and commend our staff and all the hard work that they have done through the year 2018. So I will launch into our 2018 year in review remarks. As we conclude our final meeting of this year, we'd like to revisit a long-standing custom of this commission for the chairman to recount some of the many accomplishments of the Public Utility Commission at the end of each year. So let me be clear, we have enjoyed another successful year at the commission because of the dedication and the commitment of our staff. It is only because of our staff that we have here at the commission that we have had such a great reputation and can tackle anything given to us by the General Assembly. So let me just list some of the things. And unfortunately, when you start listing things, you can't really list all of the things, but we will do our best. Dealing with the PA1 call, after a 6-month push or 6-year push, the commission now has jurisdiction over the Pennsylvania One Call, and the several bureaus have worked to successfully create the Damage Prevention Committee. Our team has live streamed 2 successful meetings, taking nearly 300 actions against facility owners, excavators, project owners across the state. On the topic of the Pittsburgh Water and Sewer Authority, you know, this year the PUC also received oversight of the Pittsburgh Water and Sewer Authority from the General Assembly. Again, a working group consisting of many commission bureaus worked tirelessly to address the changes related to making this a smooth transition, working directly with the authority, increasing educational efforts targeted at PWSA customers, evaluating the rate increase request filed by the authority, and addressing consumer inquiries in our call center. On the issue of cybersecurity and the creation of our new cyber office, we continuing our commitment to cybersecurity awareness. The commission hired a director to oversee the newly created Office of Cybersecurity Compliance and Oversight, and that is Michael Holko. This was an important step in the Commission's continued efforts to protect Pennsylvania utility customers from experiencing disruption of utility services and other vital systems and services that we depend on. During the year, we also continued to work with utilities, our state agencies such as PEMA and the Governor's Office of Homeland Security, to name a few, our emergency responders and other organizations to better prepare for cyber and physical attacks, and took part in Black Sky exercises to discuss state-level response to large-scale hazardous events. Under the topic of rural broadband and area codes and telecom, the PUC also continued its efforts to help ensure Pennsylvania's access to funding for rural broadband projects. Earlier this year, in response to the FCC's denial of a joint petition filed by the PUC and the Department of Community and Economic Development, the Commission announced its ongoing discussions with the FCC about broadband initiatives in the state. We noted that decisions by the FCC about the federal Connect America Fund Phase 2 program will impact Pennsylvania consumers, with 63 counties facing the prospect of losing funding to deploy high-speed internet in unserved and underserved areas. As part of our commitment to rural broadband, we also joined with the Center for Rural Pennsylvania to encourage consumers, businesses, and community organizations to participate in a new broadband speed test, which we linked to our website, helping to crowdsource an effort to map the state's digital divide. The Commission opened a rulemaking proposing to adopt the FCC rules governing attachments to enable more efficient device attachment practices in Pennsylvania. And additionally, as part of our telecommunications efforts earlier this year, we assisted with the implementation of the new 445 area code in portions of Philadelphia, Bucks, Montgomery, Lehigh, and Berks County. In terms of tax reform, changes in the federal tax rates also kept our staff busy this year as consumers began receiving tax reform savings on their utility bills. Triggered by the changes, the PUC ordered 17 major electric, natural gas, and water and wastewater utilities to begin adding credits to monthly customer bills beginning July of 2018. Utilities are expected to return about $400 million in annual savings to our consumers. Under the issue of utility careers and veterans, our ongoing and award-winning, shall I say, utility careers campaign took us across the state, joining with our utilities and other state agencies as we hosted job fairs and public events, including one right here in our Keystone building dedicated to helping veterans find a position in the utility field. This outreach extended to our own microsite on our website, where job seekers can learn more about our campaign and available opportunities. On the issue of year of rate cases or increases in filings, in 1 year's time, our Secretary's Bureau received approximately 26,000 filings and served approximately 12,000 documents. There are now approximately 4 million pages of the Commission's historical files online for public review. And we can easily call 2018 the year of the rate case, and I'm sure our staff would agree with that. We received 18 applications from utilities for rate increase requests. On the issue of electric vehicles, in 2018, the PUC adopted a final policy statement on third-party electric vehicle charging stations, which is a big step toward designing a regulatory landscape which supports innovating and dynamic pricing for electric vehicle charging. Pipelines, we know, is a big issue, pipeline safety, as well as the PUC's efforts in providing mutual assistance to other states. Pipeline safety continued to be a priority for the Commission this year. In addition to our in-state efforts, our Gas Safety Division provided mutual aid and sent personnel to Massachusetts to provide ongoing assistance in the aftermath of the September 13th natural gas line explosions in the state's Merrimack Valley. OCMO updates. The PUC continued moving forward on several fronts to further remove barriers to competition in the state's natural gas and electric markets. Led by the Office of Competitive Market Oversight, the PUC advanced efforts on regulations about the release, assignment, transfer of capacity among natural gas distribution companies, natural gas suppliers, and a technical conference was held in March. OCMO also launched a rulemaking to review and update the Commission's Chapter 54 electric supplier disclosure regulations, and they clarified the ability of customers on First Energy's CAP program to choose a competitive electric supplier through CAP-specific rules and standards. On our NARUC efforts and participation, the commissioners and staff also made it a priority to participate on a national level with the National Association of Regulatory Commissioners throughout the year, and also led the opportunity to continue sharing best practices internationally with different visits. And also, we want to just thank Vice Chairman Place and his staff on the most recent visit that we had 2 weeks ago from a contingency from Kosovo. And we thank them for their efforts, and also our communication staff that has been working on that as well, to share some of the best practices that we have here in our state and learn from them as well. Energy burden and low-income issues. Certainly not the last item to mention, or the least item to mention. The commission is in the midst of an exploration of energy affordability, examining the energy burden for households in Pennsylvania, or how much a family's income is spent on things like heat and light. And as a complement to that study, we are evaluating commission policies regarding universal service programs. Together with these two initiatives, will provide important insights to improve the way we serve, intended to help our most vulnerable households, and we look forward to productive discussions about energy affordability in the year 2019. And to conclude, and I know that was a laundry list, but there is much more that we can say about all of the efforts of our staff here at the commission. I just want to, along with my fellow commissioners, wish our staff and the entire PUC community for your hard work all year long, and we wish you and yours a very joyous holiday and a happy new year. And I don't know if any other commissioners would like me to join me in these comments, but if not, we just want to thank you very much, our staff. So one final note, one final announcement before we close out this year. As always, we do, as required by our Public Utility Code, we do the vote for the vice chairman for the next year. For this year, for 2019, we would like to announce that Commissioner David Sweet will be stepping into the role as vice chairman. Let me first of all thank current Vice Chairman Andrew Place for his serving in that role for 3 years. He has brought the passion, intelligence, and all those different things that we continue to see him in his efforts here at the PUC to that position, and we know that he will continue to serve in that capacity in terms of his knowledge base that he brings to all of the different issues that we discuss here at the commission, but also as we work with different efforts in NARUC and in OPSI, since he is currently serving as the secretary for OPSI. So we just want to thank him for serving as vice chair for 3 years from 2015 to 2018. And then going on to congratulate David Sweet, who will be moving into the role as vice chairman for the commission in the year 2019. So thank you very much. If there's nothing else to come before the commission, as I stated before, we wish you a happy holiday and a happy new year. And with no objection, the meeting is adjourned.